I am Dan Schulte, a member of Kerr, Russell & Weber and legal counsel to the Michigan Dental Association. There are several issues that an attorney would spot when reviewing an employment agreement that a young dentist doing this for the first time may miss. In the next couple of minutes, I'm going to highlight some of the important issues I see in almost all dental employment agreements given to new dentists. First, you should insist that the days and hours you are expected to work are spelled out. Are these hours to be spent all seeing patients? Has time been allotted for completing dental records? What amount of time, if any, will you be expected to provide administrative or managerial services to the practice? Do you plan to moonlight at another practice? Maybe you have significant student loan debt to repay or other reasons for doing so. Does the agreement allow you to moonlight? Is the employer's consent required? Second, what is the term of the agreement exactly? If the employer has the right to terminate you at will, there really is no term. Your employer is free to terminate you at any minute for any reason. This is not uncommon if your understanding is that you are being employed for a fixed period of time, like 1 year. There should be no at-will termination right. Instead, there should be a stated period of time with a list of 4 cause events that will result in your termination. Does the agreement contain 4 cause reasons for your termination in addition to an at-will termination clause? If so, why? Are the consequences for a 4-cause termination different from an at-will termination? Is additional notice from the employer required when terminating at will? Is the employer required to provide you with a severance payment when terminating at will? Does the agreement allow you to terminate? You have the right to terminate even if such a right is not provided for in the employment agreement. What amount of notice is required if you terminate? Is there a penalty if you do not provide the required notice? Third, what obligations will you be bound to following termination? Is there a covenant not to compete? If so, is the covenant enforceable? Is the geographic scope no larger than that which is necessary to protect the employer's patient base? Have you been given any information on where the practice's patients come from so you can make this determination? Will you be restricted from treating the employer's patients following your termination, or is just contacting or otherwise soliciting patients prohibited? Can you at least let patients know that you've left the practice? How about where you're going to practice next? Most importantly, does the covenant not to compete apply if you are terminated at will? It would be very unfair early in the relationship for the employer to terminate you for no reason and leave you having to move out of the area to continue your career as a dentist. The agreement should not give the employer this right. Fourth, how will you be compensated? Is the amount fixed or based on a formula? If a formula is used, are the terms adequately spelled out? Are the components of overhead and similar terms used to define the amount that will be deducted from collections arising from your services clear? What expenses are included? How are lab bills handled? Are revenues from hygiene and other services provided to patients by others in the office included in the formula? What about benefits? Who pays for time spent in continuing education courses? Who pays for the courses? Is this time off counted as vacation? What malpractice insurance is provided? Who is the insurer? What are the coverage limits? Upon termination, will you be eligible for tail coverage? This coverage covers claims brought up after the termination but arising from services you provided prior to termination. Who will pay for the tail coverage? Does it matter if the termination is at will or for cause? As I hope you can see, there might be 1 or 2 things that you may not have considered. Having an attorney experienced in these matters review your employment agreement is wise and should not cost more than a few $100s. This is much less than the potential legal costs and emotional toll later on when you have been terminated or want to quit, and you then realize for the first time what your employment agreement says or means. Good luck, and be sure to have your employment agreement reviewed by an experienced attorney.